Thank you.
SJC-11304, Commonwealth versus Horne.
May it please the Court. I'm Jane Larman White. I appear today on behalf of Daniel Horne. It's a direct appeal of his convictions in Hampden Superior Court, primary charge being first-degree murder on which the jury returned a verdict of second-degree murder. There were also firearms or rifle convictions and ammunition conviction. I would like to point out to the Court that the deliberations in this case lasted over the course of 3 days, although the third day there were 2 substituted jurors. 4 issues have been raised in my brief, and my direct appellate review application was premised on one in particular. I would like to discuss that one and one other and rest on my brief as to the other issues unless the Court has questions. The first issue I would like to talk about is the refusal of the judge below to charge the jury on the option of the lesser included offense of involuntary manslaughter. As this Court is undoubtedly aware, the scope of risk involved in the third prong malice and the scope of risk involved in the reckless and wanton conduct appropriate to involuntary manslaughter is a rather small degree of difference. Malice is based on is when, in the circumstances known to the actor, the risk of physical harm from the particular conduct is a plain and strong likelihood of death. Likewise, in the involuntary manslaughter context, we also take into account the circumstances known to the actor.
So the facts here, that somebody takes a rifle, right?
Yes.
And
yes.
shoots it 8. How many bullets?
Yes.
Through a window.
I'll
where
get right to it
people are
then.
known to live, even though you can't see it because it's covered.
This is rather crucial. There are four factors that I would suggest to the Court, and in any event, it's a jury determination. It's a factual determination as to what circumstances the actor, the shooter, would know. And so the circumstances and the physical configuration and just the information which would have been known to the actor were critical and should have been submitted to the jury rather than taken away from the jury by the judge's ruling that there would be no instruction on involuntary manslaughter. In particular, I'd like to call the Court's attention to 4 factors. One, as Justice Duffley has pointed out, is the coverings on the window. There was not only a Venetian blind that was fully extended and closed, there was obviously a thick and dark curtain that went up the full length of the window, and over that hung clothing, although not all the way down.
Did he know he wasn't at that party, was he?
He was not at the party.
Did he know did he live in that building?
No, he did not live in that building.
Was there evidence that he knew the family that lived there?
He lived down the street, and the evidence was that he had come and been on the sidewalk in front of the house some hours earlier, and there was also evidence that he had been engaged in conversation with someone who had been at the party in a place that was perhaps in an adjacent lot. There was no evidence that he had been inside the building itself.
But a jury could infer that he knew there had been a party there, right?
Had been a party, but here's another factor. In addition to the window coverings, and as to that, I would just like to point out to the Court that I had tried to take pains that the reproduction of the exhibits, the photographic exhibits, and they are from pages 34 to 36 in the brief, and they're so dark you can't much see anything. I made this morning some better copies, and I would proffer them to the Court if you like. Of course, the exhibits themselves are in the Court, and you could have access to those. I've given a copy to my sister.
Well, we can certainly agree that he couldn't see through the coverings.
Yes. The second thing, the second factor that would have been open to the jury to consider in terms of what circumstances would be known to the shooter were that the officer himself, and this goes along with the second one, the responding officer was unaware that there had been anything through the window because the window was still covered even after the shooting, and he believed and questioned people at the party as if someone in the party had been the shooter rather than outside.
But let me ask you this though: if if the defendant believed there were people in the house, it really doesn't matter whether or not he could see them when he fired the shots through the window, does it?
It does. It does very much, because first of all, as to the party issue, the district attorney below tried valiantly, but without success, to have the witness, Brianna Mercado, testify that the party was ongoing, that there were still lots of people in the house. That was an unsuccessful attempt to elicit that information. In fact, the witness testified that the party was over, that only the residents of the house were still present. In fact, all of the parties spoke of this room in the front of the house as one would rather expect in the general and normal configuration of the house to be the living room. It was after the party was over, and so an actor could believe that this was more in tune with nighttime and people retired to their own bedrooms. In fact, one witness, the woman, the mother of the victim, testified that in fact the front room had been made into her bedroom, and that she was speaking with the victim there in that bedroom after the party was over and that no other people were there. So both the configuration, or the normal configuration of the house, and the circumstances which would suggest to anyone, and in fact the exact testimony was that the party was over, that certainly a jury could find that one could believe that the residents of the house remained. But in terms of firing into a house, what is crucial, I would suggest, on the case law, and this is apparent in several cases that I've cited, including Santiago and Ferrara, which talk about what is known, that there's a difference between firing into a crowd when you see the crowd, and there's a difference in firing when you see the contours of an automobile where the windows are not obscured and there's under a street light. It's the absence of knowledge. The absence of knowledge does not excuse the behavior, but it does make possible a lesser included offense of involuntary manslaughter.
I'm sorry, I want to make sure I understand. The absence of knowledge that there are people
Yes.
who could be harmed.
Yes. When you see a crowd and there's no obstruction of view, and you fire into the crowd without the intent to particularly hit anyone, but that firing into the crowd has been held, and I would not accept to such a holding, that is a scope of risk consistent only with malice.
Well, was there evidence that the defendant was aware that the party was over?
I would suggest that that's a burden shift, and in any event, it is for the jury to determine the party was over, according to the only direct evidence on the point, which was the sister of the victim who testified to that.
And the firing occurred at 1:30 in the morning?
I'm sorry?
The firing occurred at 1:30 in the morning?
1:30, there's some testimony, it was a little later, because Linda Howell testified that she wouldn't have visited the defendant until about 1:30 after her shift at the thing, so it would have been after that, but between 1:30 and 1:45.
So no earlier than 1:30?
That's right.
Okay, now you've mentioned, I'm not sure you've got your four factors yet. You have the covering on the windows, the responding officer did not know that the bullets came from outside. Are there two more that you haven't told us?
That the party was over, and that the configuration of the house, which I've suggested, the normal configuration, and in fact all the questioning attorneys and some of the witnesses referred to the front room as being the living room, i.e. not a place that one would think sleeping people would be, and but in fact it was the bedroom of the owner or the renter of the apartment.
And was there evidence that the defendant knew what was behind the curtain?
No evidence whatsoever.
How many bullets were fired?
Eight, I
Eight,
believe,
that's
is the
what I thought.
testimony.
And this is different than a car under a street lamp, though, because the car has windows, and you can see in the car, and you can see around the car to see if anybody's walking into the car. Here you have a house where the window's covered up, a house where people live, and you don't know what room they're in, but it's reasonable to assume that they're in the house. Why isn't that more like firing into a crowd?
Because even the firing into a crowd is distinguished in the case law from firing near a crowd, and that is the critical distinction in terms of what the defendant knows he's doing. The other
But he doesn't, he can't see, I mean, the assumption, the reasonable assumption is that people are in that house. You can't, and he can't see where they are. So he doesn't know and then nevertheless shoots.
So it's, no one's talking about a required finding of not guilty. What I'm arguing is that it was open to the jury to find that this was conduct that was reckless and wanton. And it didn't come to mind when I was writing the brief, but just last night it occurred to me that however odd it would seem, that that principle is most amply illustrated, I think, by the case of Commonwealth versus Atencio, which is, of course, the famous case about Russian roulette. Now, if there's one bullet in the chamber and you spin the chamber and you hold it to someone's head and you pull the trigger, you don't know. But if there's a bullet in the chamber, that's the part you don't know. There is nothing less than a plain and strong likelihood of death. But in that context, involuntary manslaughter has been held to be a permissible result. Absolutely. The lack of knowledge is whether or not there's a bullet in the chamber.
Well, let me change the roulette scenario just a little bit. You have three paper panels, and a person is standing behind one of the three. You don't know which panel it is, and you can't see, but you know that there's a person behind one of them, and you have a fully loaded gun, and you must take one, or you take one shot
At one of the panels.
at one of the panels. Is that reckless conduct, or is that malicious conduct?
Well, my answer would be that it would be up to the jury to determine that. I've pointed out in my brief, I think, the cases that stand in such stark contrast, and I believe one of them includes someone who bound the victim's hands and, taped the mouth and bound the feet, and then with a heavy weight threw the person into the ocean. I don't think that there's any way that I would be able to argue that that scope of risk was anything other than a plain and strong likelihood of death. But the facts, all of the circumstances would be plainly known to the actor. And that's certainly not the case in my case, and that's a distinguishing point.
What's your next point? You're going to make two arguments?
Two arguments.
Okay.
I would like to go to the issue on which this court granted direct appellate review, which is the multiplicity of convictions in terms of the possession of the rifle. It was a stunning proposition in the Commonwealth's brief. I found that there was that the notion was that the statutory crime is incident-based. This was surprising to me because I myself have confronted many cases, as this court, about a mattress hiding a shotgun, and there's certainly no incident based about that. That kind of construction is just made up out of whole cloth on the statutory language we have here, and there's no support for that. The Commonwealth, I posited it as being a temporal spread of before midnight and after midnight, and in fact that is the only distinction on the two indictments. The Commonwealth came back and said, no, it was incident-based, that on one occasion the gun was shown to Joe Darko, and on the other occasion it was used to fire. The Commonwealth argues for public policy as supporting this. As I have pointed out in my brief, and as this court is abundantly aware, we do not lack for statutory crimes covering use of a weapon and enhancement of penalties therefore. This is not that statute. This is the unlicensed possession or without a firearm identification card. There are two cases that I have come across, that one from Rhode Island and one from Alaska, that are extremely good on that context, and I'll either say them to you or send a 16L letter. One is Simmons versus Alaska, 899 Pacific 2nd 931. Possession is a course of conduct, not an act. And the other one is State versus Morejon, Morejon, in Rhode Island, 675 Atlantic 2nd 410. Unless there are any other questions. Thank you.
Thank you.
Okay.
Good morning. May it please the Court, I'm Marcia Julian with the Hampden County District Attorney's Office, representing the Commonwealth today, and I will address the same arguments, as my sister, and I'll rest on my brief as to the remaining two arguments. On the issue of whether or not the judge improperly disallowed or did not give the involuntary manslaughter instruction, I would suggest that when the court surveys that the case is factually relevant to this issue, not the issue my sister mentioned of binding someone and tying them up and throwing them into the water, but where someone discharges a firearm, I would suggest that this case more closely falls on the line of the cases where it's appropriate not to give the instruction. Based on what the defendant knew at the time that he discharged his assault, it was an assault rifle, from 32 feet away from the front window, at a location that he had visited twice the same day, earlier in the evening, all for the same reason, because he was convinced that the television set stolen from his girlfriend's neighboring apartment the day before was taken by someone who was attending the party. He was heard shouting about coming out, giving the television back. There was a lot going on that day. You'll see that there was also evidence that his girlfriend was on her front porch around 5:30, 6 o'clock that evening, as witnessed by the neighbor next door, screaming about the television set. And
So there's a lot of motive that he would want to.
he targeted this house.
Okay, so
He
he shot
definitely
at the
targeted
house.
this house.
Is that enough? He shot at the house.
He didn't shoot at the house. He selected the window. And he didn't shoot at, as the judge observed, he didn't shoot at the foundation or some innocuous part of the house or up in the air to continue this threatening and harassing behavior. He shot through the most vulnerable point in the front of that house, and that was through the front window. And I would suggest that, and I can't point to it right now, but my recollection of the evidence is there may have still been partygoers present, but at least the family was present. There were people present in the front room. Four of the 8 shots struck and killed the victim.
Was it undisputed that the defendant knew there were people present?
Well, I think it's a fair inference. The defendant didn't testify, so we don't know what his actual state of knowledge was, but it certainly was a fair inference for the jury to draw that he returned to that house, this time to discharge the weapon.
Could a jury draw on the other inference, that he was not aware that there were
I don't
people
think that would
involved?
be a fair inference for the jury to draw based on the evidence.
Even given the time?
Pardon me?
Even given that it was 1:30 or between 1:30 and 1:45?
Well, Your Honor, I would suggest that there is evidence that the party had recently broken up and there may have still been some people present. Obviously, people were still up and moving about in the house because
But he
this
couldn't
young
see
lady
that,
who,
right?
no, he couldn't see that. But
Were the lights on?
there was no direct evidence, Your Honor, suggesting whether or not there were lights on or off in the house.
Were there
I can't
cars?
answer that question, I'm sorry.
Were there cars
There was
parked
no
out in front?
offered concerning automobiles parked. Yeah, I mean, there may very well have been. I don't know to whom, to which house they belonged. But I would suggest that it's the degree of risk. And he certainly knew that people lived there. He lived right across the street. He had this ongoing dispute concerning this house and this young man who had been at the party, Joseph Diarco, about this television set.
But pragmatically, you would be concerned about involuntary manslaughter only if you were unable to prove one of the first 2 prongs of intent to kill or intent to commit grievous bodily harm.
That's right.
So we're talking about the 3rd prong,
Yes.
which suggests that there was no intent to kill or no intent, that the jury at least arguably may not have found an intent to kill or intent to cause grievous bodily harm. And he did have the opportunity to have killed the other gentleman earlier, but did not. The person he met in the street, he did kill him at that time.
He did not, Your Honor, but there was testimony from that young man that he quickly hugged the defendant because he was concerned about the presence of children in the area.
Right, but I assume there's also at some time he did release the hug,
Yes, he did.
and the
but-
person walked away? The
Well,
defendant
I would
walked away?
assume that he walked away. He did. There were 3 incidents where he appeared at the house. One was arguing. The mother of the victim came out and said, "Take that down the street." There was the incident involving Joseph Diarco where he was armed with the gun, and then he returned. Now, I think it's fair for the jury to infer that he made repeated trips, ultimately to make his point. He came with a gun twice. The second time he decided to discharge it as I said, 8 times through the window into this house. And I would suggest, Your Honor, that it is a degree of risk. I don't think it's important whether or not you can actually see somebody in there. It's the degree of risk. In many of the cases my sister relies on in her brief, there was evidence in the light most favorable to the defendant, which is what the judge has to look at in deciding whether or not to give the instruction, that there were other circumstances. In one case, a witness testified, I don't think he was aiming at the person in the car. I think it's the Santiago case that my sister relies on, and I would suggest that's not a holding that this court provided in that case. That was a suggestion that shooting near a crowd is wanton and reckless conduct, but that came up in the context of a closing argument issue. So I don't think that's directly on point at all.
Where in relation to the top of in the bottom of the window did the bullet go through the window?
Well, my sister provided me with better copies of the, I don't know if the court can see it, it's about the midpoint, I would suggest, of the window.
So how tall would a person have to be if standing?
Inside or outside, Your Honor, I'm not sure.
Inside.
Well, gee, I think you might get some better
Is the window all the way
context
down to
from
the floor, or?
No, this is clearly, I mean, the sill from the window is probably in this area, and then the blinds are all destroyed partway up the window.
Okay. Now, what about the trajectory from outside? Was he firing
reconstructed.
upward?
Well, Your Honor, the transcript doesn't convey whether or not it was pointed upwards or downwards, but the ballistician, Trooper Murphy, did use trajectory rods to reconstruct the trajectory, and he did approximate there was a tree by the sidewalk outside of the front of the house, and it was 32 feet away from the window, and that's where the shooting.
Was the house? Was
the first floor.
Was the sill of the house, that rests on the foundation? Was it on a hill above the sidewalk?
There's no testimony suggesting that he was.
So we don't know
shooting.
if he was firing upwards at a steep angle, or if he was firing from a hill looking down, or if he was firing horizontally. We know nothing about that.
Well, those details were not specifically elicited.
But would it make a difference? I mean, if he was shooting at the ceiling in this house, would that have made a difference?
I think that the only case really concerning shooting at the ceiling is I don't have the name of it now. My sister cited in her brief, and I referred to it in my brief as well. And that was really more. It was really more in the context of there was evidence in the light most favorable to the defendant, in that case his own testimony, that he was being attacked by a group of women and thought he was going to be killed, so he fired a shot through the ceiling. I don't think there's anything in the light most favorable to the defendant here that would suggest he was doing anything other than what the Commonwealth's evidence shown, and was that he returned a third time angry and frustrated and saying, I was disrespected and so was my girlfriend, and he shot 8 times through that window.
He
How
said
much
that?
time
I'm sorry.
passed between his visit and then his shooting through the window?
Well, I'm not sure that we have precise times, but it's been characterized as several hours, because that comes up in the context of the second argument and whether or not possession of the firearm was continuous or under the Rashad versus Burt analysis was sufficiently differentiated.
Said the defendant was angry and he and his girlfriend had been disrespected. Was this something that he said?
Yes. Joseph Darko testified that on the second visit, where he was confronted by the defendant carrying the rifle, that they exchanged words, and then the defendant reported to his girlfriend, who testified in the Commonwealth's case, that he came back and he reported that he had talked to Joseph Darko and not to disrespect them anymore. Now there was also testimony that from the neighbor who was a disinterested party, who made observations from his home, that the girlfriend was standing on her second floor balcony around 5:30 in the evening, screaming to a young man across the street on a bicycle about don't break into my house. And he said, if I want to break into your house, I'll break into your house. So obviously, during the course of this day, this was a pretty contentious issue, and I think that would have been a fair inference for the jury to draw in this case.
Can I just ask a question? Was there any evidence about whether the defendant had ever been in the house?
No, there was no
Or
evidence about
he didn't go to the party?
No, I don't think that there's any evidence that he attended the party. It was a birthday party that started in the afternoon and went on into the evening.
And how many stories was the house?
It was a 2-story house. They lived on the first floor.
I'm sorry.
The neighborhood, a number of neighbors testified they were multiple family homes, first and second floor homes in that section of the city.
And was there any evidence that he knew that they did not live in both stories of the house?
I'm trying to remember if the upstairs neighbor testified or not. I'd have to double check that, but I don't think there was any evidence on that point as to,
But he knew the
he
party
knew the
was on
party
that-
was going on, and he knew Joseph Darko was a party goer who was in and out of the
But
house.
my question is,
during
did he know that Joseph Darko and that group lived only on the first floor as opposed to on the first 2 floors?
I should correct a misimpression. Joseph Darko didn't live at that
Okay.
house.
Is
He
there
was
any
just-
question that the people who he was shooting at lived only on the first floor as opposed to living on
No,
both
I
floors?
do not believe so. I do not believe
So
so.
we don't know whether or not he arguably could have thought that the upstairs bedrooms was where they slept and that downstairs was the living room.
Well, I don't know what the other photographic evidence was. I'd have to look at the exhibit. So I don't want to say one way or the other because I'm just not certain about that point. But a number of people from that street testified, and it was pretty clear that they were 2-family houses all along the street, both sides, a number of neighbors. And he lived on the second floor of the one. This was 55 Wilmot Street, and he lived at 37, just a couple of houses down the street.
Who did he think, on the Commonwealth's theory, stole the television?
The girlfriend conveyed this information to him, and it appeared it was a juvenile and 2 young men, one being Joseph,
One being Darko.
named Joseph. And
Darko, that he is not one of the people he thought stole the television?
I think it's a fair inference from the evidence because that's who he confronted at the party. Outside
So none of the
party.
residents of the house were the people he thought, on the Commonwealth's theory, that had stolen the television?
I do not believe that the Commonwealth's evidence tied the theft to anyone who lived in that house.
Okay.
But this, as I said, this young man, Joseph Darko, was in front of the house, in and out of the house. There's testimony about him being present for both prior incidents prior to the shooting. And it was where the defendant chose to go to stand in front of the house and yell about the TV set and returning it and not disrespecting him.
If I could turn
Counsel,
you briefly
time's
to the,
almost up.
I'm sorry,
You
if I
wanna
could,
get to your second
if I could turn you briefly to that point.
Yes.
Let's assume you have evidence that a person's been possessing a firearm in his home continuously for a month. Is that 30 counts?
No. I think the reason for that is that in Commonwealth versus Rab, this court adopted the Rashad versus Burt type of analysis, and there are other reported and unreported cases in Massachusetts that follow that line of thinking. And the question is, in the disjunctive, whether or not there's sufficient differentiation in time, location, or I think purpose was the third one, or intended conduct or purpose, I guess it is. And in this case, while the location is the same, it occurs at different times, and the defendant clearly had different purposes. I think, as Judge Kinder observed when he talked about the instruction, whether or not it was the threat and harassment was continuing or it was taken to another level. Well, it was taken to another level. He had a different purpose at that point. And I think that the cases that my sister relies on do not mention Rashad versus Burt, and they look more at a continuing course of conduct. And in this case, and I see my time is up, In this case, the defendant does not fall under one of the exemptions. He's not in his home. He is outside of his home. He is not licensed to carry the weapon. So I would suggest saying that possession being something continuous doesn't necessarily preclude someone from being charged. What if it, if it was a week apart, I think certainly the same argument would apply just because it was hours apart. I think it's a question of whether or not this court will adhere to the Rashad versus Burt analysis. And if the court has any further questions, I would be happy to answer them. Otherwise, I'd rest on my brief.
Thank you very much.
Thank you.
All right, we'll take a brief recess.